How to avoid probate. 5 ways to keep your estate out of court. What if I told you your family could skip court entirely when you pass away? No long delays, no legal fees, no drama, just a smooth transfer of everything you've worked so hard to build directly to the people you love. The best part, it's totally legal, surprisingly simple, and you can start setting it up today. Hi, I'm Jason Gray, estate planning attorney in Washington State, and if you've ever heard a probate horror story, you're not alone. From delayed inheritances to drained estates, probate is a process that too often adds pain to grief. In this video, I'll break down what probate really is, what it costs here in Washington, and 5 real strategies you can use today to avoid it. So what is probate? Probate is the legal process the court uses to transfer your assets after you die. That sounds harmless, but here's the reality. Nationally, probate takes 9 to 18 months on average, can cost 3% to 7% of the estate just in legal fees and court costs. In Washington, even a simple probate can be $7,500 to $10,000 or more. And if anybody contests your will, which can easily be done at a high cost, it can drag on for years. And here's the kicker: almost everything that probate does can be done privately if you plan ahead. Let's walk through the 5 most effective tools you can use right now to keep your estate out of court. Number 1, a revocable living trust. This is the gold standard. Think of a trust like a private vault. You move your assets into it while you're alive, and when you pass, they go directly to your beneficiaries, no court involvement. Benefits: it completely avoids probate if set up correctly, works immediately upon death, and gives you control over how and when your assets are distributed. Pro tip: make sure your assets are retitled to the trust or you have beneficiaries listed on those assets, otherwise it doesn't work. Number 2, beneficiary designations. Many financial accounts let you name beneficiaries directly. Retirement accounts, 401ks, IRAs, life insurance, some bank and brokerage accounts. When you name a beneficiary, those funds skip probate entirely. Warning on that though, outdated designations are one of the most common mistakes I see. Double check them, especially after a marriage, divorce, or a new child. Number 3, joint ownership with right of survivorship. For property or bank accounts, adding a co-owner with right of survivorship means that ownership passes to them automatically. A common example: spouses that own their joint home, and when one passes, the other owns it outright. If there is that right of survivorship, just be cautious. Adding a child or sibling as a joint owner can have tax, creditor, or conflict risks. Don't do it without legal advice. We see very commonly with deeds that right of survivorship language is not on the deed, in which case that right does not exist. So make sure that you meet with an estate planning attorney. Even if you think you have it set up correctly on your deed, best to have the experts take a look at it. Number 4, payable on death, POD, and transfer on death, TOD designations. These are powerful tools and underused. POD applies to bank accounts, TOD can apply to brokerage accounts, and in Washington, you can potentially use them for real estate. Other states you cannot. Washington allows transfer on death deeds, which would allow your home to transfer outside of probate. If you file the deed, get that recorded with the county, name your beneficiary, and then upon your death, it transfers automatically. You want to make sure that you keep that designation up to date if your beneficiary changes. And then one of the risks to consider with the transfer on death deed, and why a trust might be preferable, is there's no protections for your beneficiary on that deed from their creditors if they're going through a lawsuit, bankruptcy, divorce, or any of those things. So sometimes a trust is still the better option. Number 5, small estate affidavit. This is the life hack of probate avoidance, but only works if your probate estate is under $100,000 and includes no real property. Here in Washington, heirs can file a small estate affidavit to collect personal property like bank accounts, vehicles, personal belongings. It's fast and doesn't require a court hearing, but again, only if the estate is under $100,000. Let me walk you through how this works here in Washington. Let's say your mom passes with $80,000 in savings, a car and no real estate. You could wait the specified time frame after her death, download the small estate affidavit from the court or county website, attach a copy of the death certificate and a list of heirs, present it to the bank, and claim the account potentially without probate. It's not a well-known process, but it can save families thousands in court cost. Bonus tip, what doesn't avoid probate? Common myth, I have a will, I'm good. Unfortunately, a will doesn't avoid probate. It just tells the court what to do, but still sends your estate through the entire process. Wills equal probate, trusts equal avoid probate. Let that sink in. Now let me ask you, which of these probate avoidance strategies surprised you the most? Drop it in the comments below. I want to know. And if you want to build a custom plan for your family, click the link below to book a free consultation, because you don't have to leave your loved ones with a mess. You can leave them with clarity, peace of mind, and everything you intended for them. And don't miss this next video. YouTube thinks you'll love it.